USPTO has gotten very good in the last 5 years of sniffing out PO box domicile applications. They must have access to some pretty good tool, because every single address that comes through that's even remotely similar to a PO box or post office, UPS, FedEx box, whatever, they know about it, and they'll basically issue an office action saying that that's not the correct address.
Ooh.
And what's really interesting, there's been so many updates at the USPTO the last month.
There's a patent guru on YouTube who's claiming if your goal is to license your patent, all you need is a provisional patent. And getting a full patent for that purpose is a waste of time and money. Agree or disagree? Well, I disagree. I disagree on many fronts. I have a hunch as to who I think this guru might be. But I will say that if your goal is to license your patent, you need to actually get a patent. Okay, so to get a patent granted, you do have to file a non-provisional, or i.e. the full patent application, which will then get examined. The USPTO examiner does their own search, gives it that thumbs up, which is known as the notice of allowance, and then you pay the issue fee and get the actual federal rights granted. That's when you get the patent number and so forth. That is what is being transacted in a licensing agreement. Now, there are licensing deals that can happen with pending applications, but that word application is really vital. In this question, I'm concerned already because you're asking, all you need is a provisional patent. There is no such thing as a provisional patent. There's a provisional patent application. And a provisional patent application is one that's less formal, doesn't require a lot of the rigor around the declarations, the disclosure of invention or known prior art, as well as the detailed description of drawings and a lot of the figures and the claims being in the specification. It can really just be a description of your invention, and you can include drawings if you want, and they can even be hand-drawn. They don't need to have any specific format or function. And so it's quite easy. And a lot of inventors will be able to learn enough about patent law to be able to file a decent provisional on their own. And so for a lot of bootstrapping entrepreneurs, I think it's a great option for you to file something. It's better than not filing at all. And that's what the USPTO, the Patent Office, and the policy would actually prefer. We want innovators, inventors to tell the world, right, to file your application as soon as possible. That's why the law changed about 10 years ago. It's no longer whoever invents it first, it's whoever files it first. And so we want to reward inventors to file. And so that's why the bar is really low in terms of the technical competence and sophistication needed to file a patent application at the provisional level. But the problem is there's no federal grant. You have no rights that are granted when you file a provisional patent application. So it's really vital that you understand that. Whoever this guru is, I hope that they're clarifying it. The fact that you're asking this question in this way tells me that maybe they're not hitting that home, that you don't get any rights by filing a patent application. It's pending. And a provisional does not even get examined. So it really is just this placeholder. You could file a provisional application that says, "Hi, I'm JD." And that's the entirety of the spec. And yeah, you would get a pending application number, but there no one or no company would be willing to compensate you, the inventor, for that statement. It doesn't describe any invention, and it's not valid. So long story short, there are certainly ways to get patents licensed, but in order to get a patent license, you have to go through the process of filing a full patent. So certainly not a waste of time. That is how patents are granted. So I would disagree with that. I've developed a novel approach to buying and selling real estate, and some software tools assist the process. If the concept or business model is patentable, it'd be great to have patent protection, but I don't want to spend a lot of time and resources if it's likely to succeed. Any advice would be appreciated, and if you have recommendations for a provider, that would be helpful as well. Well, I do have a recommendation. Get a hold of us at Bold Patents, schedule a free discovery call, and we'll be happy to kind of guide you along this way. I said, yes, indeed, business methods are patentable.
Sure.
As long as you've got a novel, right, the first of its kind, series of steps, and if you're putting together valuable, technology, you're just able to get that data put together in a faster, more efficient way, identifying the right clauses, right? Lots of different ways smart contracts are put together. It's definitely eligible. So get a hold of us. We'd be happy to kind of help you think through that. One thing about business methods, I will say, that can be challenging and we always want to check with inventors about, is there's a risk of non-detectability, right? With software, business methods, these types of inventions, even if you are able to get a patent secured, it can be challenging to identify infringers.
Sure.
How will you know from the public vantage whether your invention is being infringed? So it's something to think about. Maybe you've got a good idea, and if you do, I'd love to hear it. So it's kind of part of that. Hey, yeah, we can get you a patent on it, but we want to make sure we're helping you from a holistic standpoint. Do you have a business plan? Is there a real ability for you to identify, leverage this technology, or maybe it's better kept as a trade secret? So that's one thing I wanted to mention there. Pat, any comments on real estate?
No, super cool. Real estate's interesting. They're always hard to file and register because there's so many folks in the financial services and real estate sector at the USPTO. So this would probably fall under both real estate services and maybe some sort of computer or SaaS PaaS services.
Yeah,
cool.
Got it. For a trademark in the US under my personal name, will my domicile address be public record, or only the mailing address will be provided to the public? Can a mailing address be a PO box? I want it under my personal name just in case I close my current corporation in a year or two, but would like to have ownership of the mark. Could I use a Google Voice number, personal number, to avoid people having the personal number be published? What are your thoughts on this, Matt?
Yeah, this is a great question. Get this all the time. So there's a difference between your domicile and your mailing address. You always have to provide a domicile address. It doesn't matter who you are, corporation, individual, you have to provide a domicile address.
Okay.
If you don't provide a mailing address, your domicile address will be your mailing address by default at the USPTO. Okay. So when you're filling out the form, if you want to hide your house address, right, you'll enter your house address in the domicile position or portion, and then you'll click a box for the mailing address and you'll enter the mailing address. And that can be a PO box. But of course, your domicile cannot be a PO box.
Okay, a lot of words, but that's important. So the clarification is the domicile address, so long as your mailing address is different, your domicile address will not be published.
Correct, right. Okay. And USPTO has gotten very good in the last 5 years of sniffing out PO box domicile applications. So they must have access to some pretty good tool, because every single address that comes through that's even remotely similar to a PO box or post office, UPS, FedEx box, whatever, they know about it, and they'll basically issue an office action saying that that's not the correct address.
Ooh.
And what's really interesting, there's been so many updates at the USPTO the last month. It's been absolutely maddening.
That's what we're talking today. We're talking USPTO news. So
yeah. I'd like to get a hold of that director, man. Things are really falling apart here. What's interesting about it is that, now if there's any issues with the application, so for example, like say we submit an application where the domicile address is actually a PO box, they're going to find out about it, push back on us, and they're going to charge us an extra $100 now. That's something that they haven't done in the past, but I mean, just today, because typically what we would do is we file these applications, and we want to push the USPTO as far as we can push them in terms of our clients' rights and expansiveness of the goods and services. But now, if the USPTO has to respond at all to us, they're basically issuing a $100 fee.